the Crypto Freedom Alliance of Texas in federal court that basically said, we think this rule is an unlawful expansion of the SEC's powers under the Exchange Act because the SEC can only do what Congress allows it to under the boundaries set, by statute.
This content is brought to you by VeChain, which is a leading enterprise-grade Layer 1 public blockchain spearheading a digital revolution from a sustainable, highly scalable smart contract platform. The VeChain blockchain has many unique features, which makes it an ideal choice for Web3 applications. VeChain is working with many great enterprises such as PwC, Givenchy, BMW, and Walmart China. Most recently, they partnered with the Boston Consulting Group to build a revolutionary decentralized application ecosystem. I'm a big believer in this project. I have been since 2018. I've been a VET token holder for years. And this blockchain is highly scalable, great with security and speed, and it has low energy consumption. If you'd like to learn more about VeChain, please visit vchain.org. Link will be in the description. Welcome into the Thinking Crypto podcast. I'm your host, Tony Edward, and my guest today is Laura Sanders, who's policy counsel at the Blockchain Association. Laura, good to see you. Happy Friday.
Thank you so much for having me, as always.
Yeah, Laura, big news yesterday. Big win for the crypto industry and, of course, the Blockchain Association. The dealer rule, this was struck down by the court, but let's set the table. Tell us about this dealer rule and what the SEC was trying to do here.
Yeah, absolutely. So the dealer rule is a rule that was promulgated by the SEC under the Exchange Act. And what the rule attempted to do was broaden the definition of who a dealer is under that statute. And we brought a lawsuit alongside the Crypto Freedom Alliance of Texas in federal court that basically said, we think this rule is an unlawful expansion of the SEC's powers under the Exchange Act because the SEC can only do what Congress allows it to under the boundaries set, by statute. And we thought that this rule went outside those boundaries. And we also brought claims that the process that the SEC followed to promulgate the rule was arbitrary and capricious under the Administrative Procedure Act. And really, our fundamental issues with the rule were that, there is sort of two categories of understanding that are relevant for like a legal proceeding like this. And one of them is just the statutory text. So the Exchange Act defines who is a dealer, and who is a trader. They set out definitions in the statute. Congress sets those definitions, and the SEC can use those definitions to, promulgate rules and do all of the regulatory things that it needs to do to fulfill, its mandate. Our issue was that, the rule set out here was so far outside of the statutory definition that it really kind of created a whole new category of people that the SEC was going to have jurisdiction over. And that's just not permissible under the law. And the second sort of category of references that is important for sort of a lawsuit like this is just historical references. What historically do people understand a dealer to be? It was our position, and the court agreed, that a dealer is somebody who buys and sells securities as part of a regular business, and then as a part of a regular business has to have some sort of meaning, not just, as the SEC here tried to sort of explode that portion of the definition and create it so that anytime a person buying or selling securities had the effect of providing liquidity to the market, you were de facto a dealer. it was our position that historically you would really need to have customers. You would need to be providing a service to investors in order to be a dealer.
Hmm.
And there are a lot of reasons for that that are super, boring and legal, and people can read our filings if they're interested in that. But the importance of it really is that if you are a dealer, you have to, abide by all sorts of different rules and obligations, including registering. And in our space, if this rule had taken effect in 2025, you would have seen potentially individuals who go and, provide liquidity on, liquidity providers. These individual people who have absolutely, they have day jobs, they do other stuff, they just happen to, you know, stake tokens or do whatever they do, they would have had to register as a dealer, which is just not what the statute, the Exchange Act, contemplates at all. Um, and you may have also seen, coders and software developers who create the actual, software that serves as, does what typically like a dealer might do, a human dealer might do. But there is no human here. It's
Right.
just some person who created this software. They might be in a position where they would have to register and they would have to do all of the requirements that a typical dealer, has to do. And that person typically has a whole business behind them. And in this situation, it would just be, some person who never contemplated that in a million years. And so we're just so thrilled that the court agreed with us. And, you know, it was a resounding victory. The rule was completely set aside, and we're just so relieved and so happy.
Yeah, that's a huge win, and it just shows the SEC's overreach. And whether that's Gary Gensler's agenda, maybe it is. And but Congress has to set the rules, and we know there's some legislation that is in the works. One bill made it out of the House earlier this year. Possibly one can go through the lame duck session towards the end of the year, but we need Congress to act. But the SEC was clearly overreaching, and the courts they have been the balance of power here, striking down a lot of these unlawful activities, overreach and hypocrisy, and much more. So just a huge win for the market because, to your point, this dealer rule was very far-reaching and would put a lot of people in a bind when there's no need to. It's just I don't know. Maybe it's the agenda, right? The anti-crypto army agenda, and that's the point or the genesis behind all these things.
Yeah, absolutely. And I thought it was really interesting, Judge O'Connor didn't even reach sort of our second category of claims, which are, the arbitrary and capricious APA claims, because the violation of the statute, the Exchange Act, was so egregious that he had to set aside the rule no matter what. It didn't matter how, what happened on the, APA arbitrary and capricious side, because the violation of just like the pure statutory boundaries was so clear that he, didn't even reach that. So I think it was like a 10 or 11 page opinion that he issued because, he never even reached that second category of claims because it was just such an egregious violation. And so, I think that really speaks to what we were or currently are dealing with at the SEC, which is just sort of, I think the court used a phrase that was like untethered to the text and history and structure of the Exchange Act. Really, the SEC is acting in a way that is completely untethered to all of the grounding mechanisms that they are supposed to, abide by. And we're just not seeing that at all. We're not seeing them abide by statutory, obligations or, practice and common practice that they're supposed to follow with respect to rulemaking. It's just it has been really disappointing. And so we were glad that, this, and as you mentioned, the courts have been so instrumental in terms of just having us or giving us a forum where we can kind of point out to a neutral arbiter, we're really, being treated unfairly here. This is not how it's supposed to work. Um, and so it was just such a relief to get this ruling, and particularly because, the rule was supposed to go into effect in 2025.
Hmm.
Here we are, in late November, and we have finally some clarity, and people know that they are not going to have to, be impacted by this just absurd rule in a few months, which is great.
Yeah. To your point, this news broke yesterday along with Chair Gensler announcing his plans to step down come January 20th, 2025. So a big change, and almost serendipitous that this news broke the same day he's stepping
Yeah,
down, right?
we
The
were
universe
joking.
telling us something. Yeah.
We were joking that he's trying to take the attention off of our win in the dealer lawsuit, but no, we had every expectation that he was going to do this. It would have been very unusual had he chosen to stay on or do something like that. But he definitely chose a great day. It kind of was like when it rains, it pours. We couldn't stop getting great news yesterday. And yeah, I mean, with respect to Chair Gensler, like I think it's time for new leadership there. I think we're all very excited to see where the agency goes, and he has plenty of months left, and we'll see what happens. And certainly, from a litigation and the legal perspective, we have, been told by them that, or not directly, but through the media, that they have no plans to take their foot off the gas. And so we are prepared to respond, as needed. But it was definitely expected and great news to finally see that in the headlines yesterday.
For sure. And to your point, what you were talking about, he still has a couple months left, and some people are worried that, they often say a wounded animal is the most dangerous, right? I don't I hope he doesn't do anything crazy, drop any like a ton of lawsuits on his way out. But it sounds like you guys are keeping your guard up. So we don't know what's going to happen, but just in case, you're ready to, fight back.
Yeah, absolutely. I mean, I think anyone who's been in this industry for a little while, I'm certainly no veteran, but I know enough to say that we would be fools to assume that he was not going to do something more in his time as chair. I think we are, approaching the holidays here, and they, have definitely done things in the past where they've sort of dropped a new rule on a holiday, or decided to, drop some settlements or file a lawsuit or something like that. So, we are going to be prepared through the new year. And I guess, through the end of January to deal with anything that happens. We still have quite a few pending rules out there that he's proposed and has, suggested will be finalized. So to the extent that that happens, we'll be here and ready to read them and respond as needed.
Yeah, for sure. Obviously, there's been a lot of talks of potential candidates that the Trump administration could put as SEC chair, many of which are very pro crypto or at least technology neutral. And I'm hoping we get someone who understands the technology at least. There's a bunch of names, but do you think that a new chair who's, let's say, per crypto or at least technology neutral, may drop some of these cases that are not fraud related, that are just, once again, seems very silly that they should be sued until Congress passes regulation? Do you think some of these cases maybe drop next year?
So I'll say the normal caveat, which I think we all know anyway, but it's just, I mean, it's impossible to say. I truly have no idea who this person will be or what they will be like or what their priorities will be. So, there's no way of saying. My hope is that we will see the SEC typically, and again, we might have somebody come in there who's completely going to revamp the entire organization, and so they might act in a way that we've never seen before. But typically, the SEC is sort of loath to drop a case they would rather just lose in court and kind of, reassign resources and things like that, rather than just completely withdraw a complaint, for example. Um, so what you might see instead of that is, them signaling to various defendants saying, hey, if you guys approach us with a reasonable settlement offer, that you'll stop doing X, Y, Z, we will, at that point settle. The case will drop out of court. And, that's something that we're hoping will be a big part of a new chairmanship,
Mm.
because these cases absorb so many resources at the SEC. And if you have a chair who's like, why are we going after all of these people and losing? That's a pretty big incentive to say, okay, come in, let's work together on a settlement. And you might have some defendants who say, no, we're not going to settle for anything. We've been sued for no reason, and we're going to take you all the way. And if they have the resources to do that, then the SEC is going to kind of reap the rewards that, are appropriate in those cases. Because again, you can't just pursue people because this is sort of like a niche pet project where you hate a certain industry.
Right.
So I think we're going to see kind of, some movement there. Certainly people who are pressed on resources, I hope will have the opportunity to settle. And then, the big dogs, you might see them just say, yeah, we're going to go and we're going to win. And, I would personally love to see that because I think, it kind of, it just feels like that's sort of what is due to the SEC after all of these years of tormenting our industry.
Yeah, for sure. And are there other major cases you guys are working on, or are you kind of like in a holding pattern? Let's see who comes into office as the chair, and we'll go from there.
Yeah, so it's really interesting. Right now, obviously right now, Chair Gensler is in charge. We are, ready and able to fight any new rules that he might put out there and support our industry if there are new lawsuits. So there's nothing that we are, actively taking on at the moment, but if something happens, we are ready. And then we're going to enter the period where there's going to be an interim chair.
Mm.
And that is kind of, it's a longer period. It can be several months. And, we're hoping to kind of engage with some of our, more interested, staff over there at the SEC during that time and kind of see if they are interested in, helping out with, some new rule guide or some regulatory guidance, or something like that in that interim period, to try to get the ball rolling. And then once we have a new chair installed completely, that is going to be, to your point, I mean, we're really like, we don't know what that's going to look like. So, and a lot of it comes down to sort of who is going to be, who are the division heads at that point? What are their priorities? How much do they know about crypto? I mean, for
Right.
us, we are, as an organization, not necessarily Marissa Koppel, our head of legal, and myself, but our organization is really focused on the educational component and getting an opportunity to go into the SEC and talk to whoever the new division heads are and say, look, like, we need to turn a fresh page. We would love to be, partners with you and get some really helpful rulemaking on the books because we don't know how effective the new Congress is going to be. And, we're right here. We're able to talk to you and describe the issues that we're facing as an industry and help you help us become, a really trustworthy, well-regulated industry. So certainly education will be a major priority for whoever that new chair is. And, from a litigation perspective, I'm hoping that kind of, our role with respect to the SEC will be less, adversarial and, thinking about lawsuits and stuff like that, and more just turning to the more constructive portion of the job, which is, addressing through comment letters, and, other communications with regulators, different proposals. And the rulemaking process really, if it works well, it should be, they propose a rule. We say, hey, you missed some stuff. These are the issues that you have. Like, let us help you understand these issues better so that you can create a great rule.
Yeah.
Um, and then, they go back and finalize a much more appropriate rule. That hasn't been our experience over the last few years. And so we're hoping we can kind of get back into that because there are other regulators who, we do have constructive
Yeah.
conversations with. Um, so that's kind of our outlook right now, but things could always change.
Yeah, and I love the work you guys are doing and on behalf of the industry, and it's been a lot of help and obviously a huge victory. And as you're saying that about going in and working and talking to the folks at the SEC, we know that Commissioner Mark Ueda and Hester Peirce have both been open-minded and willing to work with the industry. Hester Peirce has put forth so many rule proposals and guidelines over the years, but they seem to fall on deaf ears within the SEC. So hopefully, maybe she's the interim chair and, some of these things can make its way throughout the industry towards Congress. That would be pretty amazing.
Absolutely. She has so many proposals that, we hope will kind of get dusted off at this point and really be heard now that they're going to have a majority. And we're just so excited about that because she really has been such an, active and interested participant in, regulating our industry, which is all that we ask for, really.
Yeah. Yeah. Well put. Laura, thank you. And thank you to the folks at Blockchain Association for the great work you guys are doing. And I know the fight's not over, even though Gensler's resigning, but brighter days are ahead. And it looks like 2025 is going to be a year of progress and more of working together. But thank you so much for joining me.
Absolutely. Thank you.